everybody. Welcome back to Voice for Men India. As promised, today we are here to discuss about the latest Supreme Court judgment, which has come on Monday. And joining with us today is Amish Aggarwala. He is the advocate on record for Supreme Court, and he has been dealing with a lot of cases, a lot of matrimonial cases. So I think what we can do is we can start with all the queries which have been coming in my inbox, my DM, and we can kind of understand what this judgment has, what it means and what it is going to mean for everybody in your personal cases. So first of all, Amish, thank you so much for joining us. I've been really trying for long to get you on this show.
And this is I am going to be a recurring feature. I'll make sure of that. I'll chase you down and ensure that I can contribute to whatever extent I can at this incredible platform that you're trying to create for the men's rights movement in the country. And you have my gratitude for that, madam.
Thank you, Amish. Thank you. So let's start, Amish. So basically, Monday we came across a judgment, and it's a 5-bench constitution judgment which has come. Now, this is basically in 2 parts. The first part is about the mutual divorce, mutual consent divorce. And the second part is basically about where it's not a mutual consent divorce, where one of the parties is contesting, yet the Supreme Court has given certain guidelines. So if you can just start with a brief on what is this judgment about, and then we will take the specific questions.
All right. So it is commonly known since the past several decades or so that getting divorce is a very tedious process in India. And over and above the difficulties that we face, it is even more difficult for men who usually face the brunt. And of course, whenever I discuss this kind of a conversation, I always begin with the caveat that these laws were created to counter the difficulties that were faced in the past, but now the propensity for misuse is so high that men have become, in my opinion, a bigger victim of this entire situation. However, so coming back to the point, divorce used to be very time consuming, and although the judges of all courts, be it the trial court, the family court, the high court, and even the Supreme Court, they were very sympathetic to the view of both the parties struggling. Usually, majority of the times, what we are seeing is that the wife has availed of her legal remedies in the form of filing of criminal cases, domestic violence petition, maintenance petition before the various courts. The husband has filed either a divorce petition or a restitution of conjugal rights petition, and both of them are struggling with each other for several years without any respite in sight. And in the middle of all of this, especially I believe when transfer petitions were being filed in large numbers before the Honorable Supreme Court, what was happening was that there would be cross-border litigations between parties placed in different states. One aspect was transfer petitions. What was happening was that a lot of transfer petitions were being filed, and among these transfer petitions, the Supreme Court would see that there is perhaps a scope for a settlement between the parties. Often the Supreme Court would refer the parties to mediation when the transfer petition is pending before the Supreme Court itself. Another situation where the matter would come before the Supreme Court is, say, perhaps when a husband files a quashing petition before the High Court of the state. The High Court either declines or maybe even accepts it, and an SLP, a special leave petition, is filed before the Supreme Court in this matter before the Supreme Court, and again a possibility of mediation, compromise, settlement comes up. Now in these situations, the Supreme Court sees that although yes, compromise is happening, we are putting an end to numerous amounts of litigation, and the Supreme Court also wants parties to move on with their lives on a lot of occasions, and they're seeing the plight of the parties, and they are saying, okay, we only have a transfer petition before us, or we only have, say, an order in appeal in a criminal case against us. What are we supposed to do? And so the Supreme Court said that although all other courts in the country, whatever is happening, right, courts say we are very sympathetic to your situation, but unfortunately we can't help you out because we are also within the foundations of law. Say, for example, the High Court has immense powers, but in a quashing petition filed before the High Court is not going to say, "Oh, let me grant you a divorce." That is not going to happen. Even in a quashing petition filed before the High Court can see everything is a complete falsity. Say, for example, in a 498A quashing filed by a husband, the High Court says there's nothing that is to be there, right? Yet the High Court, says that I am also bound. I am bound by the judgment of Bhajanlal versus State of Haryana, which says that you can't look beyond the charge sheet. So there are a lot of these foundations which are there upon every single court, and that is why it's such a celebrated judgment. The it's such a venerated judgment because of the fact that the Supreme Court says that we are not, and Supreme Court of course has never been bound by the law, because although every other court is bound by what the statute has mentioned, right, is bound, but the Supreme Court has been granted this special exception, being the top Supreme Court of the country under Article 142 and no other provision of law. You have the power to do justice. In fact, to give say maybe other examples, Supreme Court is the only court which in say and and uh, in a matter in which you have say sought something, if you sought one thing, the Supreme Court can end up doing something completely different, completely beyond the reach of whatever has been sought by either of the parties, right? So this is one of those other situations where under Article 142, the Supreme Court says we will not let parties suffer any longer, and especially so when majority of the times the litigants and the judges themselves know that a lot of times they are not interested in pursuing this litigation, but the lawyers are the ones who have encouraged these litigations to proceed and to maybe even keep simmering, or to maybe even keep boiling in this pot of mad litigation. And to put an end to all of this, the Supreme Court says Article 142 will do away with this. I hope that answers the question. That's all that you had asked in this particular context, right?
Sure. But Amish, a lot of people have been asking that this particular provision has always been in existence, right? I mean, the Supreme Court, as you also rightly said, always had the powers to take a decision either ways.
Right.
And the unfortunate part is that by the time the parties would actually reach Supreme Court, it would have already been 10, 15, 20 years of their life, fighting that, if I would say, an ego battle. So people want to know what is new with this judgment, and why should we be so excited about this?
Right. So, in a certain sense, it is true that this was already being done by the Supreme Court, and in thousands of cases, this has been done by the Supreme Court. The reason why this judgment is talked about so much, in fact, why this judgment came into being, was that because around 2015 or 16, a two-judge bench of the Supreme Court, while another such request was made by the parties before it, said that we are doubtful whether something like this can be done by the Supreme Court. Or if it can be done, should the Supreme Court be exercising this kind of power, venturing into the domain of granting relief to parties so beyond the scope of the litigation presently before the court. And so what happened was the division bench referred the matter for consideration before a larger bench. A constitution bench, that is a 5-judge bench, was formed. Arguments were heard for a substantial number of time, almost I believe 3 or 4 or 5 years, and of course the pandemic had a huge issue in the middle as well. So arguments were addressed for a long amount of time, and subsequently the Supreme Court gave an affirmation, a stamp of approval to the practice of the Supreme Court and its judges, granting relief under Article 142 of the Constitution of India and allowing for ceasing of all litigations between the parties, and also grant of divorce very, very quickly to the parties. This is something that was being done, which was doubted by one of the benches of the court. Matter referred to a larger bench, and the bench ultimately said that this practice is legal, it is something that ought to be done, and therefore gave the stamp of approval of continuation, and hopefully more, more, and say maybe better jurisprudence, moving towards a more easier way for parties, where it's very easy to get married. You can get married very easily, but the law does not allow you to part ways, with the same amount of ease. And perhaps, hopefully, the the judiciary has shown a little light. Maybe the legislature may follow and also allow for a little more peaceful, a little more amicable settlement between the parties.
Right. When you said that probably it will kind of give an indication to the legislative also, because see, right now the Supreme Court has been very, very clear that coming to this court to be granted divorce under 142 is not your absolute right. Okay, it will be very, very discretionary, and they have laid down certain factors which are very clear, because they don't want either parties to get away, if they have been on the wrong side of the law, or there have been multiple criminal cases, where the verdicts have been against one of the parties. So they have particularly laid down several factors. One of the crucial factors says that if the separation between the couple has been for more than 6 years, and there have been enough efforts done by multiple courts to kind of mediate, to try and find a way if they can come back together. But if that itself has failed and the parties have been living apart for the last 6 years, that should be a reason good enough for the Supreme Court to kind of bring the matter to an end and close, the chapter in all the other courts. But what, the most important question which is there in everyone's mind is, I come back to the same thing, is by the time you reach Supreme Court, it's not going to be 6 years, it's going to be much, much more. It's going to be 10, 15, 20 years. And the people who are stuck in the lower courts right now, let's say there I got questions from many people saying we are in the family court for the last 8 years, 9 years. So what do we do? Can we jump our line? Can we jump the queue and directly go to Supreme Court? How will this work?
Same query was posed before the Supreme Court. I'm sure a couple of petitioners in the Supreme Court and couple of amicus curiae, the officers, the lawyers which were appointed to argue in the matter, may have argued in favor of this. But the Supreme Court has clearly laid down in this very judgment and said that you cannot come directly to the Supreme Court, or for that matter, even before the High Court. The Supreme Court has discussed the scope as well as the limitations of Articles 32 for the Supreme Court and Article 226 for the High Court of the state. And the Supreme Court says that we are not going to allow for the possibility of a person coming for enforcement of their fundamental rights in a matrimonial dispute and say that, okay, parties have settled that this thing, and now please, waive off the cool off period and give us a respite from the statute. The courts have said none of that. But the courts have said that yes, in appeal or maybe in a transfer petition, if you come before the Supreme Court and the matter is pending before the Supreme Court, then we'll do it. Now, if someone comes to a very innovative, very sly lawyer and says that I am stuck, what am I supposed to do? One thing that the lawyers will explain is, you cannot say, for example, if a matter is going on for several years before the trial court or before the magistrate court in a DV matter, or maybe the family court in a 125 matter or a divorce matter, and you can still file a petition before the High Court because it has supervisory jurisdiction over all the courts underneath it under Article 227 of the Constitution. The same cannot be done before the Supreme Court because the Supreme Court does not have any provision where you can say that, oh, trial court, although yes, provision is there, but the Supreme Court does not entertain it. You cannot either directly go before the Supreme Court under Article 136 of the Constitution of India in a special leave petition. Ideally, if you were to go to a maybe very sly, very smart lawyer, very innovative lawyer, that lawyer will recommend that one of the quickest ways to do it will be if there are maybe two states involved. One of the parties files a transfer petition before the Supreme Court, you appear before the Supreme Court, try and get notice issued. If notice is issued, most likely mediation efforts, if both parties come and say, let's give it a shot at mediation, matter goes into mediation cell, everything gets wrapped up, the matter gets placed before the Supreme Court, but you also run the risk of the court being able to figure out that this kind of a sly thing is being done. Another thing you can do is perhaps one of the quicker ways I would say is if an FIR is registered against a husband before, in any state, he can move a quashing petition before the High Court of that state. And if the High Court passes an order, in fact, I would say any order, say maybe it dismisses it, of course, you can go in special leave before the Supreme Court and then the matter can be there. Or say perhaps, some sort of stay on trial has been granted by the High Court, appeal can be done against that. Stay on trial has not been granted by the High Court, or some other thing, you can again take it to the Supreme Court, any interim order also. So basically, either in a cross-border thing, the easiest is the transfer petition, or in say maybe everybody is in the same state, so there is no, I mean, you just got one High Court, and even if you want to transfer, you'll have to apply before the High Court itself. In that case, what you do, you approach the honorable High Court of the state, if quickly, for the hope of an effective remedy. And if that is denied, or if it is allowed also, the opposite party, whichever the case is, with the aggrieved party can approach the Supreme Court, file an SLP, and there try to get the matter referred to mediation. This is the quickest way you can go about it. But this is again, this is sly law tactics. But if we are talking about the law, the judgment says you cannot directly approach the Supreme Court, and neither can you directly approach the High Court, because in all of those circumstances, the statute has to be followed. You can't directly come to us, or even in this way indirectly. The only method available, usually 99% of the times, either a transfer petition or challenging the order of the state High Court.
Right.
Yes.
A personal question, which, because you were talking about finding ways, could people also approach Supreme Court with anything to do with child custody cases?
Again, if there is no remedy under the Constitution of India or any of the relevant statutes, such as there's the GWA Act, there is nothing which is available. What you can do is, again, move the family court, ask interim orders, and most of the times, if you're a husband, interim custody order is something which is denied most of the time. You appeal before that the High Court. High Court says, "Are you bonkers?" and dismisses, and then you move the Supreme Court. But in all of these situations, again, I say that there is a risk. There are a couple of risks, in fact. If on the first date itself the Supreme Court does not issue notice, which happens with approximately, I would say, 50% of the special leave petitions that are filed, then again there is no use, right? If you go to the Supreme Court and say, "My lord, may please refer the matter to mediation," it's very unlikely the Supreme Court is going to do it without even issuing notice, right? So you need to be careful. You need to strategize accordingly. And I always say this: you have to be very careful. If the Supreme Court catches you in, and it is figured out that this is, say, perhaps collusive litigation, in that case, hell hath no fury. In this case, nothing, no other institution, no other individual like a Supreme Court judge. Very recently, just as an example, we saw that a person who was convicted of an offense, and I think sentence for about 1.5 years or something like that, 18 months was granted. A larger sentence was granted by the trial court. The High Court reduced it to about 18 months, and the person approaches the Supreme Court, says, "No, please give me an acquittal because I want my back wages because I was a public servant as well." The Supreme Court two-judge bench said, "We are dismissing your appeal, and we strongly feel that a higher sentence should have been imposed upon you, and that's why we are issuing notice to you again, because we are not going to punish you today, but we are issuing notice against you today, asking you why we should not impose a higher sentence upon you." And to which the council is flabbergasted. But of course, again, under Article 142, the Supreme Court has the power to do anything as it pleases, even when the state has not challenged the order of the High Court and saying that, please increase it. The accused convict person is saying, "Please reduce it." The Supreme Court can say no. And if you invite the scorn of the judge, and in that case also, the counsel for the petitioner begged the court and said, "My lord, I'll withdraw my petition. My lords may kindly not do this." And the judge is in that moment obliged. So you have to be very careful. Do not pull off any antics. You have to be very careful about what kind of remedy you're seeking from the court, what kind of provision of law you are invoking before the trial courts, and then you're bringing it up in appeal before the Supreme Court. You have to be very careful.
Right. So then, effectively, we are concluding, Amish, that there is no way that people can jump the queue unless there is an absolute need to approach Supreme Court in a genuine case. Otherwise, the cases will continue the way they are continuing, and unfortunately, nobody knows when they would really reach the Supreme Court.
Well,
So,
I mean, see, again, if say perhaps we were to talk about an illustration, I could perhaps share because we recently, very about, I think, just a few days ago, we got this order in which the parties were actually married in April of 2021 itself. So just about exactly 2 years ago. And within about, I think, a year and a half of the litigation, I mean, within 1 year of the marriage, within about 4 or 5 months of the litigation starting, the parties reached the Supreme Court. Now, if because it's a very interesting case, and if you'll allow me, say maybe 4 or 5 minutes to kind of go through this particular situation, this will also give us an insight into the practical way the Supreme Court deals with petitions under, I mean, not petitions, but reliefs which it is granting under Article 142 when a matter is pending before it. So I'll
sure,
just do
sure.
a screen share
Yeah.
which can maybe illustrate as to what can be done if you want a quick compromise divorce in this particular
So this,
situation.
I'm assuming, is going to be helpful for people who are contemplating to file for divorce. I think because the ones who are already stuck, I mean, they
Well,
have to
I
only
would
press
say let
things
us go
to
through it
pass.
because this would be enlightening, I believe, on a couple of levels for a
Sure,
couple of interesting litigations, and they'll be able to kind of figure
sure.
out their this thing. Is the screen visible? Wait 1 second. I'll have to, I
Yeah,
think,
I've just
it is
shared
visible.
it. So
Great. So yes, so this is in the Supreme Court of India. A transfer petition was filed by the wife against the husband, and the case that was filed by the husband. What was the case that was filed? We'll go that into that in a little more detail down below. So the order is the dispute is amicably settled, and of course I have redacted the details leading to the identity of the parties for their confidentiality. But there's a very interesting thing that I wanted to share, maybe which will kind of shed more light into how Article 142 is used by the court. So, his dispute is amicably settled between the parties. Learned mediator of the Supreme Court Mediation Center has submitted a report along with the settlement agreement duly signed by the parties. So, the matter was referred to mediation in this particular matter, and the mediation cell, the mediation center, both the parties agreed, an amount was fixed, which was also is being discussed below, and the matter was then placed back before the Supreme Court. The two judge bench, I think the three judge bench of the court. So the said settlement agreement is taken on the record. The statements made in the settlement agreement are treated as an undertaking to this court. The parties have also handed over a joint application seeking disposal of all the pending proceedings between the parties and granting of decree of divorce by mutual consent, praying before this court to exercise its jurisdiction under Article 142 of the Constitution of India and giving an end to the relationship between them, which is taken on the record. Now, as for the settlement between the parties, two demand drafts, the sum of Rs 70.5 lakhs has been handed over by the learned counsel appearing for the respondent husband to the learned counsel for the petitioner wife. The same have been handed over by the learned counsel of the petitioner wife, which were accepted by her. Taking into consideration the relationship between the parties have been irretrievably broken down, and the parties have agreed to give an end to their relationship by way of mutual consent. We are inclined to exercise our powers under Article 142 of the Constitution of India and allow the application. Now, just to kind of take a moment to explain what is going on here, the Supreme Court sees that there are multitude of proceedings which have gone on between the parties, and therefore it is better that it is clear that there is no possibility of reconciliation between the parties, and therefore this union stands dissolved. Now, this is a matter where the husband, I believe, had not even. Yes, I'm sure because I was the lawyer for the husband in the matter. Even in the trial court litigations, we did not file for divorce, at least initially, because personally I do not believe that filing a divorce petition against the wife when it comes to availing of your legal remedies is something which has much benefit, because as we all know, these proceedings get dragged on for several years. Wives also can easily not come to the court for about a year or so, and the court keeps issuing notice upon notice upon notice, and no adverse orders are usually passed against the wife also. Because of multitude of reasons, we did not even file for divorce. So even otherwise, it's not that in my divorce case the family court could have said let us go ahead and grant divorce to the parties when the matter has been settled. We would have had to withdraw their divorce petition, and then we would have had to move a mutual divorce petition. And even then, from the very inception. Then, first motion being granted, we applying for certified copy of the first motion order, we seeking a, filing the second motion, that being placed before the court. It would have been a minimum process of, I would say, somewhere between, say, um, between about 2 to 3 months' time to obtain mutual divorce between the parties. And in the middle of all of this, things can still go wrong. Either of the parties can backtrack. Then one party files a compromise, one party files a contempt. The other party wants to reinitiation of the litigation. And then you'll have to file maybe a quashing on the merits of the matter. Withdrawing sometimes becomes a problem. So uh, you know because we could have gone through all of this effort, rather than doing that, we straight away proceed with this particular thing that happens. And what was the case that was filed? Again, that will also come down in the details below. Accordingly, the marriage stands dissolved by mutual consent. Registry is directed to draw the decree accordingly. The decree was then drawn. But now this is what is interesting. The following cases between them stand quashed and set aside. FIR so and so place, which was registered by the wife against the husband and his family members. Application under Section 12 Domestic Violence Act leading to so and so case pending before Mahila Court Saket, initiated by the petitioner. Now, this is usual rigmarole that the wife initiates against the husband and his family members. What we had done was what we had filed was the item number 3, civil suit pending before learned civil judge, initiated by the respondent, that is the husband, that is my client. We filed one civil suit for a particular cause of action, another civil suit pending before learned additional civil judge, Bangalore, initiated by the respondent. Now, this is the particular suit that we had filed before the Bangalore City Civil Court for on behalf of the husband. Despite the parties being based out, both parties being based out of Delhi, we still filed this one civil suit in Bangalore, which the wife then subsequently filed a transfer petition to get it transferred from Bangalore to Delhi. And of course, I must clarify, this is not a collusive suit of any sort to invoke the jurisdiction of the Supreme Court. It is just happenstance that this happened. And that to multitude of reasons, because we had initiated this Bangalore civil suit approximately almost 1 year prior. And what had happened was that there were several causes of action in which we had availed of our legal remedies against the wife and her family members. One of which the causes of actions took place in Bangalore instead of Delhi. And that is why the plaintiff, having the ability to choose the forum which is convenient to him among the various forums available, as is allowed for under the Civil Procedure Code, we did that. Now, in that particular matter, the lady filed a transfer petition, and when notice was issued, the Supreme Court did not even stay the proceedings of the Bangalore civil suit, because of which the lady had to ultimately also engage an advocate and appear before the Bangalore court. And in the meanwhile, the they were also proceeded ex parte. So all of these things happened, and that is the reason why the lady had to approach the Supreme Court. If, say, for example, I filed my case in Tisazari and the lady has filed her case in Saket court. No court, in at least in Delhi, is going to transfer the case from Saket to Tisazari because of the minimal distance between the two district courts. In, say, for example, recently I had a matter where um, there were two cities in Punjab, one Gurgaon, and the other was a city far away, approximately, I believe, 200 or 300 kilometers away. So the lady filed a transfer petition before the Chandigarh High Court. So Supreme Court you can't go to, and again this thing kind of got stuck. But Supreme Court, you need to have cross-border jurisdiction between two states. So this is what happened. We filed a civil suit. Subsequently, we filed another civil suit for another purpose. This is an FIR that we had also gotten registered for theft against the wife. We filed a domestic violence petition by the mother of the husband against the wife. We filed a complaint under Section 200. The screen is visible, right?
Yes, yes.
We filed a criminal complaint under Section 200 of the Criminal Procedure Code, again in Tisdari courts, by the husband. We filed a suit for recovery in Dwarka court, which was again this was another. There was a loan that the wife had taken. There was some sort of a transaction. So for recovery of a certain amount, we had to file a civil suit before with other jurisdiction. And so the court, in its wisdom, this quashed all of these cases in one single go. Now, if the parties were left to their own devices, one or the other impediment could have kept creeping up, either in Bangalore or in Dwarka District Court or in Tisdari District Court or in Saket District Court. Right? In either of the cases, we initiated or the wife initiated. And so the Supreme Court, when it saw that all of these proceedings are being culminated, I mean, effectively, then why should we not just put an end to all of these cases right away? And so immediately all of this was done, and this is an order of somewhere in April of 2023 itself, and we were able to have this whole thing disposed of end to end. So I'll just stop the screen sharing. And the reason why I wanted to kind of share this particular thing was because of the various learnings that people can get, right? One thing is, how do you approach the Supreme Court? I say again, this was a very genuine grievance between the parties, right? This husband said, I can choose Bangalore, I chose Bangalore. Of course, he filed his other civil cases, criminal cases, all of these other, things under the law against the wife. The wife then moved a transfer petition before the Supreme Court saying that everybody is in Delhi, why can't it be Delhi? And here, the matter was referred to mediation, and the parties were able to, over several months of mediation, they were able to figure their distance out. 17.5 lakhs was the amount that was agreed between the parties. I must say the initial figure which was demanded was almost, I think, around 6 times more compared with this particular figure. So so there was some respite for the husband as well. But this was ultimately done, and of course, you and I both know, majority of the times, in fact, I would say that to take it a step further, I would say that even if, say, for example, there is an arranged marriage or a love marriage which fell apart very quickly and things didn't work out, and parties realize that we're not meant to be with each other, right? Majority of the times they make their peace because they know, at least, say, for example, under Hindu law, at least 18 months you cannot do anything from the date of the marriage, right? You have to wait a minimum of 18 months, no matter what. And only then can you approach the family court for a mutual consent divorce, maybe move an application for waiver, etc., etc. So all of these difficulties anyways will be still there. However, if you are availing of your legal remedies, the opposite party is availing of their legal remedies, at least you can hope. So in this particular case, this screen sharing that I did, right, the parties were married in April of 2021, and the litigation started very soon, approximately, I think, 6 or 8 months into the marriage. These litigations he initiated and the other party initiated, and all of this came to fruition exactly 2 years later, and within 24 months the whole saga, from marriage to divorce, ended in this whole thing. But yes, madam, to answer your question, um, if you try to do it in a particular way, and you try to, a sly advocate would recommend something like this if the parties have both kind of done it. I've had many clients, I've had men and women approach me and say that, I got recently married, say about 3 months ago. Now I want a divorce, and can you please like do this one Article 142 thing? And I tell them, this is not going to happen the way you are thinking. But I would also like to think that it is not something that would take 5 or 10 or 15 years. You know, if parties can mutually solve it out, it can happen very quickly. And maybe in one of those few off cases, maybe in about 2 or 3 years of the marriage taking place, even if some sort of glimmer of hope is there, the parties can amicably settle the matter. Yes.
So I am still assuming this is going to be beneficial perhaps for the people who are going to get married, or perhaps who are contemplating to kind of separate, because these things need to be planned before you start your proceedings. But the people who are already stuck in family courts or high courts for the past many years, I think they will have to still follow the due process until and unless they reach the Supreme Court. And even after reaching the Supreme Court, it's going to be a discretionary power with the judges, whether the marriage has been broken down, and then whether they need to dissolve it or not. Amish,
Absolutely.
I also want to ask you, just before this Constitution Bench judgment, last week, in fact, on Friday, there was another judgment which has come from the Supreme Court, which was a two-judge bench judgment, very similar on lines of irretrievable breakdown of marriage. Now, that case again was, very, very peculiar. The parties were married only for 4 years, from 1994 to 1998. Okay, and there had been a separation for 25 long years. No kids, parties are living separately for 25 long years. And ultimately, the matter reached the Supreme Court, and the Supreme Court has dissolved the marriage. But they have made a very categorical point that if one spouse refuses to divorce, even after so many years of separation, you can deem it as cruelty to the other spouse and then dissolve the marriage, because until then, there is really no ground, because we follow the fault based divorce process. So they said, okay, this could be considered as cruelty if one party is still not agreeing to divorce. So, will this theory be also floated by the lower courts? Will the messaging go down from the Supreme Court to the High Court, at least the High Court, if not the Family Court? That, if there has been substantial number of years of separation, and if one of the spouse is not agreeing, we can deem it as cruelty to the other spouse and dissolve it under that particular section.
Yes, it is definitely going to permeate to the High Court, and whatever the Supreme Court lays down, either as an absolute mandate to be uh, to be followed down by all the courts, or maybe a judgment has been passed in a particular case, the courts of law always follow it, and they are always considering what is going on. However, practically speaking, I say that even when we talk about absolute concepts like fault-based divorce, of course, irretrievable breakdown of marriage and the Naveen Kohli, Neelu Kohli judgment, which kind of brought into existence this gap in the statute. I believe family courts also, to a small, to a decent extent, they are also trying to kind of grasp it, and they are trying to make their amends also. And sometimes when the family courts don't do it, the high courts are a little more, also a little more open-minded. The difficulty that I see is whenever any judgment, any ruling is passed by any court, the even in case, say for example, this particular judgment, I have seen that um, judges of the courts below, be it the high court or be it the trial courts, they are very hesitant to implement anything unless it is given in so many words. So if it would have been said you have to do it like this, they will follow. But now if the Supreme Court is kind of said that only we can do this, but these are the reasonings that we want to do this, the courts, I believe, would still to a certain extent be a little more conservative in their approach and resort to doing what they've always been doing. I'll give a small example. The Supreme Court has, since the past few years, been emphasizing very strongly that you do not want to keep the parties waiting. Allow for the waiver of the cool off period. However, whatever now, say for example, the Amardeep Singh judgment has been mentioned in this particular judgment that we are discussing today, and in earlier judgments as well, it has been the leading point of authority on whether the court should waive off the mutual, the cool off period or not. And just a couple of months ago, there was this one matter where the husband and wife, they never went to court. They decided among themselves. They went to the lawyers. They drew up a compromise deed, and everything was very very amicable. When not even one single complaint, no case was filed. And the husband very amicably gave a more than fair consideration to the wife, and they filed for first motion before the family court. The family court grants first motion but says, I am not going to waive off your 6 month period. I'm giving you in writing right now. And these are parties which were married for almost about 25, 30 years. So it's not something that, oh, it's been 6 months to the marriage. But the court says that no, there have been no efforts of mediation between the parties. And that is the reason why I'm telling you I'm not going to do it. The client comes to me at that stage and says, we still want this waiver to be done. We filed that waiver application. The judge says no. I said no, and I'm giving you my reasonings now. The judge dismisses our application for second motion, and this is just a couple of months ago, and says that because as per compliance of Amardeep Singh judgment, there has been no mediation between the parties. I am not going to waive off the cool off period. And we are arguing there that because there was no dispute between the parties, there was no occasion for the matter to be referred to mediation. And of course, pre-litigation mediation is always there, but neither of the parties have gone to the court yet. The lawyers are there if the compromise deeds have been drawn up. Why do you want us to go to the court and go through the whole mediation process? Everything is done. But the judge still dismisses our application and says, now you still wait for about 6 months. So we challenge that order before the Delhi High Court. Now, Delhi High Court, the single judge, is far more open minded, says to my face that Mr. Agarwal, I have no difficulty. I think that if parties want to separate, they should be allowed to separate. But my difficulty is if I allow your particular application, I am going to open floodgates, right? And I don't want that to happen either. So the court ultimately grants our relief and waives off the cool off period, but says that this is only a one off case and I'm not going to allow it to stand as precedent. And then sends the matter back to the trial court and says you grant them the second motion and then proceed. And it is at that point of time that the family court conceded and passed that second motion. So, but that was a couple of months ago. And if maybe this judgment would have been there a couple of months prior, we would have been maybe able to even more strongly convince the family court judge that you don't need to dismiss this waiver application. But we are definitely, the whole legal community is also hopeful that, all right, as long as, if the parties are not, there is no meeting of minds, okay, fine, the dispute drags on a little. But if parties have kind of mutually agreed together to part ways and whatever terms and conditions, and of course the court also supervises that no spouse should be made a fool and made to sign on something which is, say, maybe unenforceable or maybe which is against the law. The court supervises that, and that has also been mentioned in this particular judgment, the Shilpa Sailesh judgment. So the court has taken care of this, and again we can be hopeful that the trauma and the harassment of the parties when they have come to an agreement should not be stretched out.
Because from whatever I cover as cases, I have been seeing multiple courts giving multiple the same type of cases. They have been viewed very differently by different judges. Like last year, in fact, there was a spree in cases from Punjab and Haryana High Court where two judge bench, they were absolutely, they were applying this formula: 10 years separation, 12 years separation, 15 years separation, one party not agreeing, take it as cruelty, grant divorce, and end the matter. So last year we saw a series of those judgments coming from there. But again, maybe the Bombay High Court will view it very differently. Madras High Court will view it very differently. So that is a sad part of it. Right now there is no uniformity in the way these judgments are exercised, and it totally depends on how the judge on that particular day is viewing your case.
That is correct. I agree. And hopefully things will change.
Absolutely. And the last point, which again, as I represent the voice for men, the most crucial part, Amish, is that our divorce laws are not fault based, but ultimately the alimony has to be paid only and only by the husband. So, do we foresee any kind of change? Because, see, I mean, of course, there are very, very genuine cases also where the women are not independent. The women have given up their careers to raise a family, to raise children. And in those cases, if the separation is happening, naturally the person who is earning more has to provide for the other person who is not earning. But then there are cases where, the husbands argue that it is not me who is at fault. The wife has deserted me unilaterally, or maybe the wife is wanting to move on with someone else. Even in those scenarios, why should a husband only be accountable to pay alimony? And the fear comes from, this whole Article 142. If, let's say, one of the parties goes to the court, this is a reverse case. It's not always that the husband is going to go to court for divorce. Let's say a wife goes to the Supreme Court and says that, our marriage is broken and the husband is not agreeing to it. So kindly, exercise your powers under 142 and grant us divorce. And as a woman, I also need to be granted alimony so that I can sustain myself. Now, would you think that will not be, kind of unfair to a lot of men, who have to like kind of shell out money, because the court chooses to dissolve that marriage without any fault being proven?
Well, that is something that I lament on a daily basis myself. A lot of times when husbands say, I want divorce, I want to file divorce, I also explain to them that when you're filing divorce, there is a possibility that while in your divorce petition, divorce is being granted, you have maybe proved cruelty, maybe you have proved desertion to whatever degree. The family court will most likely still fix some permanent alimony amount. There is, there's a, it's very difficult to um, avoid it. One thing I always tell husbands is that is why, and for other many other reasons, I personally do not recommend either filing divorce or filing restitution of conjugal rights. I am always much more bent towards availing of your civil and criminal remedies under the law, where no matter what, even if say a wife is asking for a transfer of the case, you don't, even if that transfer petition is being dismissed, which has happened in a bunch of our cases, the wife is not given any transportation, any travel expenditure, none of those things happen. And the wife also, at the end of the day, of course, see, if both the parties are coming on an equitable this one particular client in a mutual divorce, without going to court, without any sort of cases being filed, he himself gave up 60 crore rupees to his wife, and he was happy to do so. And he said, I have no problem, I want to give it to her. I love my wife to whatever extent time we were there. There's approximately, the multiple, assets involved. Approximately, I believe 60 crores was the amount that was given by the husband to the wife. And when you are giving from your own heart and you are agreeable to it, it is completely fine. But when the court is fixing it on arbitrary, ideas or arbitrary figures being thrown about, inflated figures being thrown by the wife on every occasion. I am earning, say, 1 lakh rupees a month. Then the wife says, oh, he earns 10 lakh rupees a month. Please give me 3 lakh rupees a month as interim maintenance, and say maybe 2 crore rupees as compensation in a DV matter, right? Or permanent alimony I need for sustenance for myself. I don't earn anything. All the while the lady is, say, maybe double masters, and she's maybe earning handsomely, but she is not disclosing her as income affidavit. Husband's moving a perjury petition, nothing's happening there. 100 challenges there in all of these things. But at the end of the day, do I personally think that the Supreme Court is going to notice this trend of filing of false cases, this trend of no fault of the husband, yet he will, him having to shell out money, part with almost one third, half of his net worth? I really don't see any respite, honestly, because the way I see it is this: it is the intention of the government, the parliament, the lawmakers, which is also that intent is also followed by the judiciary, which I strongly feel that one way or the other, they feel that the women of this country, our women, are not somebody who can take care of themselves. And from the date of the birth of a woman, her responsibility, one way or the other, is imposed upon a man. Till that, in fact, under maintenance laws of this country, a boy gets maintenance till the time he turns 18. Justice Chandrachud created a little bit of a deviation, said in one particular matter, opened up the gates a little and said that at least till graduation you must pay maintenance for the boy. But the girl, and usually the responsibility of maintenance falls upon the father, right? In these kind of cases, the girl has to be given maintenance till the time she gets married. I find it very amusing. Why is it that only till marriage? Why? Because the lawmakers know that we have made sufficient provisions for now the responsibility of the wife to be foisted upon the husband. So at any given point of time, there is one person who has to be responsible for a woman in this country. And when you have this kind of a mindset, you cannot avoid avoid imposition of either interim maintenance in the initial phases or permanent alimony at later stages. One thing you can do if you are a husband facing false allegations, of course, it is very easy for people to say, oh, when the cases are over. But you and I both know what happens when the husband is able to conclusively prove that the allegations against him are false. In perjury proceedings under Section 340 CRPC, and this is something that, say, for even if we, venture out from matrimonial matters, even in the Sarabjit case that I'm doing right now, the burden that we are facing is under 340 CRPC. We have to prove that not just say prove beyond reasonable doubt the case was completely false, right? So we have to collect that much more proof to show there was a completely false case. Second, we need to show that there was malicious intent by the lady. Now, how do we show malicious intent? How do we show the mindset of the criminal in a litigation that we want to initiate against a particular? And the third is, these perjury proceedings must be in public interest. So if it is not in public interest, apart from these two conditions, it won't be public interest. And if there's no public interest, that you're able to establish that the conscience of the society as a whole has been shocked, it's almost as if it is a, a murder case where you are deciding whether you want to impose death penalty or not, right? All of these conditions being there. So, a free pass is being given, in fact, in this country to a particular section to the oppression of another section, right? And in the presence of all of these factors, I say that the best thing that you can do is at least avail of all your legal remedies against the opposite party, not just say perjury or malicious prosecution proceedings at a later stage, 10 years down the line after everything is wrapped up. But if you've been a victim of, say, extortion, intimidation, defamation, harassment by the wife and her relatives, avail of your legal remedies, right? As a husband, file your civil cases, file your criminal cases, right? If, say, maybe there is a boyfriend involved, if the wife has a boyfriend, a lover with whom she has conspired, or maybe she can't get over him, or during the marital before between the during the marriage going on, you've got the boyfriend angle as well. File a civil suit for damages for inducing my wife to alienate her affection towards me. Avail of your legal remedies and try to get justice. And of course, as a side effect, if in the process of you availing of your legal remedies against the wife and her relatives and her devious friends and her devious lovers, if you're able to secure for yourself a better negotiated alimony amount, or maybe some occasions no alimony amount in these mutual compromise proceedings, and the wife sees that I can also suffer some harm rather than restitution of conjugal rights, which has anyways no impact, divorce, which good for me, I'm going to get permanent alimony. Instead of all of this, it's better that you avail of your legal remedies. Best case scenario, you get justice when you're able to show in court, independent of all the nonsense that your wife has filed against you, your proof in the court in the cases that you have filed against the wife, where you are concretely seeking that either you get compensation the way Johnny Depp did, or say, for example, she goes to jail for her actions. Defamation is a punishable offense, so is extortion, and so is criminal intimidation. You avail of these legal remedies and see the possibility of a much more amicable, a much more reasonable alimony sum, or sometimes even no sum at all. This is what I would suggest to husbands, rather than thinking about or hoping that the Supreme Court is going to take plight, or the High Court and the trial courts are going to follow suit with the Supreme Court and take plight on the situation of the husband. Sorry for my rant, but this is what I would recommend as a practical process.
Right. No, as you know, we also generally say that every case is different, and somebody who is suffering immense domestic abuse in his marriage would sometimes prefer to obviously set out and file for a formal divorce, so that at least he can break free from that daily trauma. But again, every case is different, so I think plan how you want to file your cases. Don't just go and file your case and then realize that I don't have anything ready with me, I don't have any evidences. So plan in advance, and you cannot run away from the reality. As Amish also said, the laws in our country are so biased towards women that even if you are not at fault at all, you will still be accountable to pay maintenance. uh, if the wife is agreeing to a mutual settlement, then obviously there will be one-time alimony which will be involved. If she's not agreeing to settlement, if she's not agreeing to give you divorce, then also as a husband you are liable to pay her maintenance for the rest of her life that she's alive, or unless she remarries. So whether we like it, we don't like it, these are the laws on ground. I think every individual just needs to understand and figure out himself how he can neutralize the other party, and what is the best negotiation, if I may use the word, can happen, and how soon and how fast he can get out from these problems. So this is what the situation is on ground. And to conclude today's session, yes, the Supreme Court has kind of affirmed that they will kind of dissolve all dead marriages. but unfortunately you will have to wait for your turn till you reach the Supreme Court. You cannot go out of turn to Supreme Court unless you are, in a situation where you are permitted to go to Supreme Court in certain cases, like Amish said, whether it's a transfer petition or other issues where you're not really planting to go to Supreme Court. So this is how we will proceed. As of now, we can only hope that the high courts at least start taking cue from here and try to push cases faster to at least allow a window for people to move on in a case of appeal or whatever in the next court, so that there can be resolution as soon as possible. So thank you,
Agreed.
Amish, for joining us and for giving us your insights on what you think about this judgment. If anybody wants to, have more answers or any particular questions, you can DM it to us, and we will try and do more sessions with Amish in the coming months on this. So thank you,
Absolutely.
Amish.
Pleasure, madam.
Thanks
Thank you
for
so
joining.
much. And for whoever's watched us for so long, thank you for bearing with us for so long.
Thanks. Bye bye.